Well, good morning, everyone, and thanks so much for joining us for the Ontario Ombudsman's first webinar. This morning, we'll be talking about how we deal with complaints related to municipalities, and we're going to turn to our speakers in just a moment. I just have a few small housekeeping items first. So first, as you know, we've asked you to submit questions in advance. That's because we have close to 300 people tuning in today, and we wanted to try to address your issues during the presentation, as well as touch on some more specific questions afterwards. So after the PowerPoint has been finished, I'll be back up here to pose those questions to our speakers. Secondly, this entire presentation will be available as an archived video for you to share with your colleagues or anyone who might be interested. And we'll be sending around that link in the coming days, as well as posting it on Twitter and Facebook and sharing it in our newsletter. So make sure you follow us on those accounts or sign up for our newsletter to receive that, as well as receive updates and information about our office. So our speakers today, beside me, will be General Counsel Laura Pettigrew, who many of you may already know from various AMCTO events, and Director of Investigations, Sue Haslam. First, I'm very pleased to welcome our new Ombudsman to the podium. He officially starts tomorrow, but has generously offered to be here today to introduce himself to you and say a few words. Mr. Paul Dubé's career has been in law, and he established the office of the first Taxpayers Ombudsman of Canada. We are so pleased to have him join our office and team. Without further ado, Mr. Paul Dubé.
Well, thank you very much, Ashley, and good morning, everybody. And thanks for coming out bright and early on what in Toronto, at least, is a very soggy day, a very wet day indeed. So this is the first time that the Office of the Ontario Ombudsman has ever done a live webinar, and I'm happy to see that we've had such a great response, a positive response. As you know, this jurisdiction over municipalities, universities, and school boards is entirely new for us, and so I'm excited to be taking on this role at a very historic time. And I think that it's very important for this office to build relationships and to continue building relationships among stakeholders. And so, especially with the new stakeholders like yourselves. So this is a very big priority for me as I take on this role at this historic time. My intention and the intention of the office is to keep the lines of communication open amongst all stakeholders. So the Ombudsman Ontario team is already off to a great start. They've been doing outreach events across the province of Ontario, and they've been meeting with municipalities, universities, and school boards to discuss the role and the function and answer your questions and take suggestions on how we can work better together. Now, generally, the theme of this webinar is what to expect when the Ombudsman comes calling. What I like to say, and it's one of my mottos as Ombudsman, is that what you can expect are no surprises. Our oversight involves assessing fairness and transparency, and I think that as an Ombudsman, it's important to walk the talk and to be fair and to be transparent in your processes and your procedures. And so what I hope people will learn about me as I evolve in this role is that fairness is very important to me. Fairness is part of my DNA, and I like to say that I'm hardwired for fairness. And so that's what an ombudsman does. We evaluate fairness to determine if services, procedures, and programs work as they should. Now, we're not here to name, blame, and shame. That's not what the game is about. In fact, most of our work is done behind the scenes. It's out of the public eye. And so, whenever possible, my priority is to find win-win-win situations. I can't stress this enough. So we want to hear from you. We want to interact with you. And that's how we can work with you and help you serve the citizens of Ontario better. And maybe we can even prevent problems and complaints from arising. So it's really about making things better for the people of Ontario, and I know that that's what you want, and that's what I want too. So without further ado, I'm going to let my new colleagues, Sue and Laura, explain more about the office, how we deal with complaints, and what to expect when we call. And I promise we do not bite. Thank you.
Today, Sue and I are going to cover a number of points. We're going to talk about what the Ombudsman is, a little bit about our mandate and powers in terms of our statute, the Ombudsman Act, and then how we actually handle complaints at the office. Then we'll give you a little bit of information about our new jurisdiction and so far what our experience has been since January 2016, and then there will be an opportunity for questions. Over the past weeks, months, we have been hearing a lot from municipal stakeholders. We held roundtables around the province in conjunction with the Canadian Public Policy Forum to hear questions, concerns, and to meet folks around the province. We have attended many conferences, done speaking engagements and outreach. And one of the things that a lot of people have indicated is a sense of trepidation, fear of change. What's going to happen? What can we expect when the Ombudsman comes? And I think a lot of that concern is based on lack of understanding about how we operate. In the municipal sector, a lot of people know us from our work as the default closed meeting investigator since 2008. And that role is very different than our role in terms of complaint resolution in terms of our general jurisdiction. Complaints about closed meetings involve an enforcement role. They're very legalistic. They're usually involve a formal investigative process. However, that's very different from the vast majority of cases that we deal with, which are dealt with informally. Through our outreach and education efforts, which have increased recently, we're trying to dispel some of the myths and misunderstandings about who we are and how we operate. I'm going to start at the beginning. The first modern parliamentary ombudsman was created in Sweden over 200 years ago. The word ombudsman, and I'm not sure I'm pronouncing that right, is actually Swedish. It's a gender-neutral term, and there are currently ombudsman offices all around the world. The idea behind an ombudsman is that the ombudsman is a citizen's representative, someone who facilitates communication and resolution of issues between the ordinary citizen and the halls of power, the government, the bureaucracy. We have had an ombudsman in Ontario for over 40 years. In 1975, the first ombudsman was appointed. Currently, every province in Canada, with the exception of Prince Edward Island, has a provincial ombudsman of general jurisdiction. The ombudsman is an officer of the Legislative Assembly, similar to the Auditor General, to the Information and Privacy Commissioner, the Environmental Commissioner. Currently, ombudsmen under our Act serve a 5-year term, which is renewable. And we've had the pleasure today to meet Mr. Dubé, who will take office tomorrow. The Ombudsman is appointed by an all-party select committee of the Legislative Assembly. And that reinforces the independence and impartiality of the position from those that the Ombudsman oversees. Today, we have jurisdiction over 500 plus provincial government organizations, and traditionally that was the Ombudsman's jurisdiction over provincial agencies. That includes ministries, agencies, boards, commissions, corporations. Now we have added 82 school boards, 21 universities that receive direct regular funding from the province, and 444 municipalities. And the fundamental basic role of the Ombudsman under the statute is to carry out independent and impartial investigations of public sector bodies. Our services are free. The Ombudsman and his staff operate under the Ombudsman Act. The staff have delegated authority under that Act. And currently we investigate over 1,000 bodies. We can investigate complaints from individuals, from corporations, from associations. We can also investigate complaints brought forward on behalf of constituents by members of provincial parliament. And the Ombudsman also has a unique power. The Ombudsman can investigate issues on his own motion. Generally, that is used in a case where we see a systemic issue. Maybe someone hasn't complained to us, but something arises in the media or in the Legislative Assembly that's of concern that appears to be impacting a large group of individuals, and the Ombudsman can initiate an investigation. One of the things that a lot of people are confused about is the scope of our authority. Our Act makes it very clear that we investigate administration. The Act describes that the Ombudsman's function is to investigate any decision or recommendation made or any act done or omission in the course of the administration of a public sector body. In the provincial context, this has meant that the Ombudsman does not investigate legislation. The Ombudsman does not investigate regulations. The Ombudsman does not investigate orders of council or orders of council coming out of the Cabinet Office. But what we do investigate is the administration, the application of those legislative decisions by government officials. Now, Bill 8, sorry, this is out of order. This is just a slide concerning our jurisdiction in terms of closed meeting investigations, which I referred to earlier. We investigate complaints that municipalities have held their meetings closed to the public improperly under the Municipal Act. We currently act for about 213 of Ontario's 444 municipalities. It's a default jurisdiction. If a municipality hasn't appointed its own closed meeting investigator, then we have jurisdiction. So Bill 8 changed the landscape in terms of our authority. Under Bill 8, as of September 1st, 2015, we've had the authority to investigate complaints about school boards. And as you likely know, as of January 1st, 2016, we now have authority to investigate complaints about municipalities as well as universities. There are some exceptions to our investigative authority, and they are set out in the regulations to the Ombudsman Act. Excluded from our authority in terms of local boards are children's aid societies, boards of management for long-term care homes, public boards of health, police services boards, and library boards. And that's consistent with exclusions in terms of local boards for accountability officers under the Municipal Act. Our legislation also specifies that in terms of the City of Toronto, administrative conduct that can be reviewed by the City of Toronto Ombudsman is not within our Ombudsman's jurisdiction. What we can do is review systemic complaints about the City of Toronto, including complaints about council members or the accountability officers such as Integrity Commissioner, Auditor General. Our office currently has staff of 86 employees. That's the budget has been increased in contemplation of the fact that we are growing our organization. We have doubled our jurisdiction. We handle close to over 20,000 complaints and inquiries a year at this point. Just to give you a sense of the typical complaints that we get, this was last year's annual report. The number one was Hydro One, and the reason for that is that we were conducting a systemic investigation of Hydro One. They had changed their billing system, and it had resulted in all sorts of issues for their clients. We received actually a record number, 11,000 complaints regarding that organization that year. Typically, we receive a lot of complaints about bodies that are responsible for determining income and benefits for individuals. Family Responsibility Office, which enforces child and parental support orders, the Ontario Disability Support Program, etc. We also had a spike last year in terms of the private career colleges branch because of a closure of a private career college that resulted in hundreds of complaints coming to our office. I'm going to just go through the steps that the legislation, the Ombudsman Act, sets out. But I want to preface my comments by saying, in the vast majority of cases, we are not applying the strict formal investigative requirements of the Ombudsman Act. We emphasize resolving complaints informally using alternative dispute resolution techniques. And when we do launch a formal investigation, as Mr. Dubé indicated, it shouldn't come as a surprise. We work informally with bodies trying to get to resolution, and it's only at the point where that's no longer possible. And there's a significant issue, it's having impact in individuals, and we feel that we have no other recourse. As a last resort, we will launch a formal investigation. So formal investigations start with a notice to the head of the public sector body. And in terms of the municipal sector, that means with respect to a municipality, it's the official council member or a committee that is designated by bylaw as the head for the purposes of receiving our notices. Similarly, with local boards, it's the designated individual. For municipally controlled corporations, which we also have authority over, the Act contemplates that there will be regulations indicating who the head is. We haven't seen those regulations yet. Our Act also confers very robust investigative powers. We can require disclosure of information and documents from those that we are investigating, and staff and officials from public sector bodies during our investigations are required to cooperate with our requests. We can also summons anyone that we feel has significant information for our investigation to come and attend and testify under oath or affirmation. We also have the formal power of entry, and there's some notice rules around that, which allows us to inspect premises. Typically, historically, the circumstances under which we've used that power have been when we've had complaints, for instance, the correctional system. I mentioned the top complaints. I didn't talk about the correctional system. We have authority over all the provincial correctional facilities in the province, and we receive thousands of complaints about those organizations every year. And sometimes we get complaints about the conditions of confinement. And those are the types of cases where we might do a formal inspection to see what the state is of these individuals and how they're living. We also hear a lot when we go out into communities of concerns about frequent complainers, individuals who may be perceived as vexatious or frivolous by an organization, and old complaints, stale complaints that have been around a long time. And people say, well, what are you going to do about those? They don't have any merit. Well, we have broad discretion under our legislation not to investigate. So we consider every complaint that comes in, we look at the facts, but we also have the discretion to apply a determination that we are not going to investigate. We have a lot of experience dealing with folks that have very long-held grievances. We tend to call them querulants. They may be very committed to an issue despite what anybody will tell them to the contrary. And we provide a neutral, independent, impartial venue to really assess those complaints and add credibility to reasonable and well-thought-out decisions and actions at the local level when we review a matter. Now, you'll see at the bottom of the slide it says offense provisions. Yes, the Act does create provincial offenses. If you hinder the Ombudsman, if you provide false information, if you mislead, there is a potential to be charged and convicted, and on conviction, there's a fine up to $500 and/or 3 months in jail. We have never used those provisions. I've been at the office for quite some time, and I'm not aware of them ever being used, but they're there to underscore the seriousness of our proceedings. Fundamental to Ombudsman work is that we operate with confidentiality. We have a very unique situation. We get access to all sorts of confidential and sensitive information that otherwise wouldn't be available to the public. And our Act creates protections to ensure that that information isn't inappropriately released. The Ombudsman takes an oath of secrecy and impartiality before starting office, as well as staff cannot disclose information except in limited circumstances. We have to keep information confidential. Our investigations are carried out in private, and no statement or information that is given to us by witnesses can be used in proceedings in court or in tribunal proceedings, except if the person has perjured themselves under oath. The Ombudsman process is also protected from judicial review, and documents and information supplied to us are considered privileged. In addition, neither the Ombudsman or his staff can be called to testify in court or in a tribunal about information that has come to our attention and the work that we have done in the course of our duties. Also, information cannot be accessed in our office through the information and privacy legislation in the province. As a result of the recent amendments in Bill 8, the legislation has also created provisions in other legislation that protect the confidentiality of our process. So if a municipality wishes, if a council wishes to consider an ongoing Ombudsman investigation, it has to be closed. It has to be a closed meeting. So there's a new exception to the closed meeting provisions in the Municipal Act, I believe 239(3)(b). And consistent with our role as a last resort, we have not only the discretion not to investigate inappropriate cases, but the Act provides that we cannot investigate where there is a statutory right of review or appeal on the merits until it's been exercised or exhausted. Now, our process, the nature of our process, it's not adversarial. This isn't a tribunal or a court where parties are coming together in conflict and trying to reach a resolution. We are neutral. We have a neutral fact-finding process, and we issue non-binding recommendations. There's no final determination of rights or responsibilities. And therefore, our Act says that no one's entitled to a hearing. It's an investigative process. In terms of fairness to those involved, the Act requires that prior to issuing a formal report and recommendations, the Ombudsman's office must give the affected persons, and in most cases this is the organization in question, an opportunity to respond to preliminary opinions, findings, conclusions, and recommendations. We've developed a process in our office to protect what we refer to as our preliminary reports, to ensure that they can't be accessible and to protect the integrity and confidentiality of our process. And what we've done is we give out our preliminary reports for a limited time. They aren't to be marked, they aren't to be copied, they aren't to be discussed. Then the organization can provide their comments, and those are reflected on our final reports, which are often made public. In terms of the municipal sphere, those provisions have now been entrenched in our legislation. So municipalities must comply with our requirements, and they prevail over record-keeping requirements in laws and bylaws, as well as over the Municipal Freedom of Information and Protection of Privacy Act. If an organization, in terms of the preliminary report, a preliminary report may go out and it may resolve matters. We may never finalize a report. It really depends on the circumstances and the nature of the response the organization is given. But if the Ombudsman is not satisfied with the response to the preliminary report, the response will be reflected in the final report. It may be attached, but there is another opportunity to respond. There's a final report, and the body has another chance to indicate that they're going to implement the Ombudsman's recommendations. If that doesn't occur, in the provincial sector, what happens is we table our reports. We bring our reports to the Legislative Assembly and they become public documents. In the municipal sphere, this is going to involve sending the municipality, in the case of local board or municipally controlled corporation, the municipality would also get a copy of the report, and at that point in time, they can be made public. And we like to say, because we don't issue orders, we can't compel anybody to do anything. The greatest power of the Ombudsman is moral suasion, to, through publishing the results of our investigations and our recommendations, to provide momentum through publicity to encourage implementation and improvement of programs and services and various other things we can make recommendations on. Our experience has been that most of the recommendations we make are accepted and implemented. And in cases where there has been a resolution, short of doing a full formal report, we often will provide a summary of those successful cases in our annual reports and other publications. Now, the Ombudsman is required to reach opinions in the way that they're set out in the Act. And there's very broad scope for reaching opinions about administrative conduct. For instance, the Ombudsman can find that it's contrary to law, unreasonable, unjust, oppressive, wrong. And the Ombudsman can also determine that administration of a piece of legislation or a regulation is based on legislation or regulation that is unreasonable, wrong. And the Ombudsman can make very broad recommendations in terms of improvement. He's got very broad scope to do that. So that's sort of the legislation, an overview of the legislation. And now Sue Haslam is going to talk a little bit more about the nuts and bolts of how we go about our work.
So let me tell you a little bit about our teams at the office and how we handle complaints. The early resolution team deals with individual complaints that are usually those that can be resolved very quickly. The investigation team, it also deals with individual complaints. These tend to be a little more difficult, complex. The Ombudsman's Special Ombudsman Response Team, also known as SORT, they deal with the broader systemic investigations, and you may be more familiar with that team because many of the reports and investigations that are completed by SORT are published. The legal services team is also involved in dealing with individual complaints, usually more complex. They also have the OMLET team, which is the Ombudsman Municipal Law Enforcement team, and that part of the team deals with all of the closed meeting complaints. The legal team is also involved in research and training in the office as well. And as we were gearing up for our expanded jurisdiction, they were very much involved in supporting and providing training to our teams in order to prepare for our new jurisdiction. Now, we are an impartial body, an impartial fact-gathering investigative body. And so when we say we are, when a complaint is resolved, when we indicate that a complaint is resolved, we mean that it's resolved to the point that we, as the oversight agency, is satisfied. And sometimes this doesn't necessarily mean that those contacting us are satisfied. We are not advocates, so we don't advocate or represent people who complain to us, complainants, and we also do not advocate or represent for the government. The Ombudsman only becomes an advocate once an investigation has been completed and recommendations have been issued. At that point, the Ombudsman then advocates for the recommendations to be accepted and implemented in the interest of the public. The early resolution team receives complaints through telephone, email, through our website, as well as individuals that attend our office. We have also set up a dedicated phone line for municipal calls. The vast majority of complaints that we receive are handled by the early resolution team. That team is composed of approximately 30 staff, plus 3 managers and a director. Early resolution staff use alternative conflict resolution strategies to try to resolve complaints. The focus always is to resolve complaints and keeping an eye for any potential systemic problems that we may need to take a closer look at. The first thing that the early resolution team does is contact the complainant to get full details about the circumstances and to gather any other information and documentation. They also conduct research and contact the organization for additional information. All of our intake calls are audio recorded and saved to our case management system, and this assists us to ensure that we have accurate and complete information. As mentioned earlier, we have the discretion not to investigate in certain circumstances. For example, if the complaint is vexatious or frivolous and not made in good faith, if our initial review doesn't reveal a problem, if there appears to be another remedy that is available and suitable, if there has been a significant passage of time which makes it very difficult for us to conduct a thorough review or an effective review. As mentioned, we are an avenue of last resort, so many cases are resolved by referring individuals to already existing internal complaint processes or appeal mechanisms. Some complaints are closed without us requiring to contact an organization. But sometimes we do have to make inquiries and gather additional information in order to be satisfied that we are ready to close a complaint. We keep track of all complaints that come to our office and complaint trends. This helps us to assess whether there is a potential systemic issue requiring full investigation. We also keep an eye on potential problem issues. Staff will send internal alert emails when they receive complaints that are compelling and potentially serious. We then can triage these complaints early in the process so that we can determine who should be assigned the complaint, and we can immediately take steps to work on them. We also have a couple of really helpful in-house tools that allow staff to share information internally. The first one is the Personal Ombudsman web resource, which you can see in front of you. And we also have a wiki, and this is based on software similar to the Wikipedia. And this allows staff to share information and research that we obtained in the course of our reviews. More than half of our complaints are resolved within 1 week, and about 3/4 are resolved in less than a month. For the investigations team, we have approximately 16 generalist investigators. They carry a caseload, and on the more complex files, we may partner them with another investigator or an early resolution officer. Investigators, like early resolution officers, continue to conduct further research. They make inquiries, they obtain documents, they may interview witnesses over the phone or by Skype or in person. And like early resolution officers, investigators focus on resolving issues by various means, and we have a really good track record of doing so. Most cases are resolved informally, without an investigation. And as mentioned before, even though the individual complaints we look to resolve them, we also keep an eye for potential systemic or broader complaints that we may be able to find solutions for. We focus on looking at the root causes of the problem, and our focus is on improving processes, policy, and practices going forward. If an investigator is unable to resolve a complaint, there's a few steps that we take. First, we try to escalate the complaint up the hierarchy of an organization. So we bring it to the attention of senior officials, and we try to resolve the complaint by doing so. The other option we have is to raise individual complaints at our quarterly meetings. And we have quarterly meetings with senior government officials with those organizations with the highest number of complaints. And at these meetings, we talk about individual cases, and we also share complaint trends, because this helps the organization to identify some hot spots or areas where there are some concerns or issues so that they can be proactive in their approach to deal with them. Now, if the complaint remains unresolved after we've attempted to resolve it informally through escalating it or at the quarterly meeting, then we may need to launch a formal investigation. But I have to tell you that only a very small fraction of cases do go to the formal investigation stage. And as Laura and Mr. Dubé advised you earlier, there will be no surprises. You will have information about our intention to investigate well before you receive our notice to investigate. And before we begin any investigation, we do a lot of planning. We prepare a very detailed investigation plan, which sets out our strategy and timelines. In accordance with the Ombudsman Act, we are required to notify the head of the organization of our intention to investigate. In the case of a municipality, this would be a designated member of council or a committee. The notice that we send you is in the form of a letter, and it sets out generally the issue that we intend to investigate. We also typically send out a letter that we call a wish list letter. And in that letter, we set out all of the documents we would like you to send us, as well as a timeline. We also ask for any information relevant to the investigation that is not listed. Officers and employees and members of the public sector are required to comply with our requests for information. And as Laura mentioned earlier, we can also summons anyone to give evidence, but this is usually reserved for situations where there are credibility issues or cooperation issues or other exceptional circumstances. It is not something that we regularly do. It's very rare that we do it, but it does happen when we need to. In preparation for our expanded jurisdiction with municipalities, we set up a dedicated municipal team. This municipal team is composed of early resolution officers, investigators, legal counsel, and senior management. We thought it would be important to set up a dedicated team to develop a specialty in the area of municipal complaints. Leading up to our jurisdiction, the dedicated team received training, and training is ongoing in municipal matters. We also, as mentioned earlier, have a dedicated municipal phone line that has also been set up. Municipal complaints are flagged to this dedicated team, so when calls come in or letters come in, these complaints are, an email is sent around to the municipal team to indicate the nature of the complaint, and this allows us to triage those complaints and determine whether they should go to the early resolution team or the investigations team. It also allows us the opportunity to consult on the complaints, and this is very helpful, particularly because this is such a new area of jurisdiction for us, and we are still learning. We also share information with the dedicated team regarding the number of complaints we've received, so statistics, as well as any trends that we are seeing in the types of complaints coming in about municipalities. We hold really helpful weekly meetings with the municipal dedicated staff as well, and this gives staff the opportunity to talk about cases and to share information. Here's one example of a case that we were able to resolve very quickly with just a couple of calls with the municipality. A man had contacted our office with concerns about his sidewalk. He said that he had been trying to resolve this problem for a number of years, and he had been calling the municipality about clearing the snow. Despite his efforts to raise this concern with the municipality, he complained that no action had been taken. He noted that other sidewalks close to his neighborhood were being cleaned. However, his sidewalk area was not. The day that he contacted our office, there had been quite a heavy snowfall, so he had told us about the 4 to 5 feet of snow that was on the sidewalk, making it very difficult for his children to walk to school, and also making it very difficult for his mother, who was a senior citizen, to visit, and that she was not visiting because of this problem. Now, our staff immediately called the municipality, and we inquired about the situation. We were told that for a period of time the sidewalk was in disrepair, and there were equipment issues that had been affecting the municipality's ability to clear the snow. The municipality acknowledged that the sidewalk had been fixed some time ago, and they also agreed that it was time that they should start clearing the snow from the sidewalk. The municipality agreed to meet with the complainant and to explain that they would, going forward, clear the sidewalk's snow. So that was a very quick resolution that we were able to facilitate through contact with the municipality. In this next example that I'd like to provide you, we have received various complaints about the conduct of council members for a particular municipality. While reviewing the complaints, we determined that the municipality had a code of conduct, but there were no clear mechanisms for making a complaint. In response to our initial inquiries, the municipality created a new page on its website. This page included a copy of the code of conduct, which had not been posted previously, and it also included information about how to make a complaint. The municipality also took a further step and created a new form to use for this type of complaint. The complaint process that they put in place initially called for the clerk to investigate and respond to alleged breaches of the code of conduct. When we called the municipality to discuss that process, we drew attention to the fact that it was a little unusual for the clerk to perform the code of conduct investigations. The process was soon amended to provide that such complaints would be referred to council, and that council would arrange for an appropriate investigation of the alleged breach of the code. Now, Laura, I'm going to turn it over to Laura so that she can tell you a little bit more about our Ombudsman response team, special response team.
Now, the Special Ombudsman Response Team is responsible for the investigations and reports which tend to end up on the front page of the newspaper. There is a director and about 6 or 7 investigators that work for the team, but that team can also call in resources from all over the offices, lawyers, investigators, early resolution officers when necessary. And the SORT team carries out serious, high-profile, systemic investigations that affect a large number of people and that have significant impact on Ontarians. Now, I know I'm asked quite frequently, what is a systemic issue? What's the difference between an individual and a systemic issue? Well, individual issues, an individual coming forward with a complaint can raise an issue that's unique to them, that's not going to affect anybody else. But quite often, even individual complaints raise issues about a system. There's a practice, there's a policy, there's a rule, something that not only affects the individual coming forward, but affects others. So we consider that a systemic issue. Even when we're conducting early resolution of a complaint, at the early resolution level or at the investigative level, we are looking for systemic issues and looking for improvements to systems. In terms of the Special Ombudsman Response Team, cases come to the team when we've monitored trends and patterns of complaints, and we see there's an issue that's endemic. It's not going away. Looking at individual cases isn't going to solve the problem. We monitor what's happening in the media, in the Legislative Assembly. We're looking for issues, root causes of problems, so that we can be most effective in terms of complaint resolution. The investigations carried out by the Special Ombudsman Response Team are by and large formal. There are formal notices of investigation. Quite often they're publicized to ensure that we have witnesses coming forward. They're of significant public interest. And quite often those investigations result in public reports and recommendations. Since 2005, the Special Ombudsman Response Team has carried out 35 large-scale systemic investigations. And they've been very successful. We have had many of our recommendations implemented as a result of our SORT investigations. And they've served as a catalyst for significant change in government policies, programs, and even in legislation. Our investigation into the Ontario Lottery and Gaming Corporation brought about significant changes to ensure protection against fraud in terms of the provincially run lotteries. Our investigation into the newborn screening program in Ontario resulted in significant changes and enhancements to that program, which have resulted in literally saving lives of children in this province. We have also assisted individuals with better access to cancer drugs. And we've shed light on a very disturbing trend in the correctional system of the code of silence, where inmates were abused and things were covered up. Our most recent report of last year related to Hydro One's billing practice and the timeliness and effectiveness of its response to customer complaints. We made a number of recommendations which were implemented. If anybody follows Hydro One, they may realize it is no longer within the Ombudsman's jurisdiction or the jurisdiction of any of the legislative officers as a result of legislation that came in to reflect the fact that the government was partially privatizing that particular body. We have two ongoing systemic investigations that SORT is looking at. One has to do with the services and programs available to adults with developmental disabilities who are in crisis or urgent situations. And the second is looking at the Ministry of Community Safety and Correctional Services and the direction that it provides to police about de-escalating conflict situations. I'm just going to briefly tell you about our open meeting law enforcement team. In the municipal world, as I said at the beginning, this is where most of you will be familiar with us. We have received about 1,000 complaints since 2008 about municipal closed meetings, and we've done a lot of outreach and education work in this particular area. We have issued a Sunshine Law Handbook, and it's been provided to all clerks, all councillors in all municipalities of the province, and in December we issued our fourth omelette report about our work in this particular area. And as I said, omelette cases, open meeting cases, are very technical. We're looking to see if the exceptions have been properly applied in the Municipal Act, allowing municipalities to close meetings. We're looking to see if the procedure bylaws have been properly applied. They're very technical, and they are formal. In most cases, we are going to investigate formally and issue reports. And we've been trying to get information out to the councillors, to municipal staff, and to the public about our work. As I said, in terms of the Sunshine Law Handbook, information on our website, and that will continue. But it is very different. It's an enforcement function, and as Sue described, the way we work in most cases, when we get a general complaint about a municipality, it's likely not going to result in a formal investigation and report. Now, to date, the kinds of issues that people have been complaining to us about shouldn't come as a surprise to anybody. Service complaints, we get complaints about the activities of council committees, local boards, conduct, conflicts of interest complaints, infrastructure, lots of services, snow removal, garbage. Programs like Ontario Works, housing, municipal hydro companies. While Hydro One is no longer within our jurisdiction, we do have authority over municipally controlled hydro companies. Lots of people not happy about taxes and fees. And I'm sure out in the municipalities, you know the issues that you're hearing about. We're likely hearing about the same things, often from the same individuals. Now, these statistics were current as of March 29th, so far since January 1st, we've received 920 complaints about municipalities. More than 600, about 600 were closed as of March 24th, so we're probably over that at this point in time. So you'll see many of them were closed very quickly. And some of the things stakeholders are saying about our office. When the Bill 8 was coming through, what we heard a lot in the news was municipalities a little confused about what our role would be. and thinking, well, municipalities, other than Toronto must appoint an ombudsman and an integrity commissioner and a lobbyist registrar and an auditor general. But with respect to other municipalities, it's discretionary. But some who had those officers were saying, well, we don't have to appoint our own accountability officer anymore. The ombudsman can be our integrity commissioner. The ombudsman can be our auditor general. And that's really not what's intended. Others said that, having the ombudsman would be redundant when we have local accountability officers. And that's not the case. We work differently. We like to underscore we are a last resort to individuals. When it comes to an organization that has an accountability officer, say an integrity commissioner, our act says that we cannot get involved in a complaint until such time as that particular commissioner has refused to investigate a matter, has finished their investigation, or the time limit for bringing a complaint to that officer has expired. So when people come to us and complain, the first thing we do is try to find a local complaint resolution mechanism that we can refer them back to. And we find that it is best for municipalities, for other bodies, to create their own process for resolving complaints, tailored to their own needs and reflecting the context in which they work. And having those local complaint processes and accountability officers reflects good governance, good democratic principles. And our office isn't intended to duplicate or replace those officers. Our role, when you've got an accountability officer in place, we're not going to go out and redo the work of that officer. We're going to see what they've done. We're going to look at the scope of their authority. We're going to look at the practices and policies and the terms of reference for that office. We're going to make sure that everything was done the way it was intended to be done, and we may make system recommendations for system improvement. We're looking at gaps. We are looking at the bigger system in those cases. Now, we conducted a survey of all municipalities, school boards, and universities to find out what kind of complaint resolution mechanisms they have, what kind of schemes they have to resolve complaints at the local level. We sent them out to everyone. To date, in the municipal sector, we've received from information from about half. We've got about 218 survey responses from the municipal sector. And what was very interesting to us, because we sort of canvassed the climate before Bill 8, and we knew that there were some integrity commissioners, a handful of auditor generals, only one ombudsman, and that was the mandatory ombudsman established under the City of Toronto Act. And not very many lobbyist registrars either. But when we got our survey results, things had changed a bit. We now saw 63 integrity commissioners were reported to us. There may be more. As I said, we've only had results from 218 municipalities. 11 municipal ombudsmen, that's 10 more than existed prior to Bill 8. 11 local auditor generals and 2 lobbyist registrars. We also get questions, well, what happens now with the closed meeting investigators? As I said at the beginning, the municipalities can appoint their own closed meeting investigator. That hasn't changed. And the statute doesn't create us as an appeal for those closed meeting investigators. If you've got your own closed meeting investigator, we will refer folks to that closed meeting investigator to have their concerns dealt with. And we won't review the work of that investigator. There may be some instances where we will look at, in terms of the municipality and any terms of reference or direction that they provide to their closed meeting investigator, if we see any gaps or concerns in terms of that process. And somebody said the other day when they saw the slide, you should have 2 ears up so that you're listening from both ears. But we're just really concentrating hard, and that's why we have the 1 ear down and the 1 ear up. We're really going out there and listening to what people have to say. We want to develop a cooperative dialogue, constructive dialogue with folks out there in terms of our new jurisdiction. We're all in learning mode at this point in time. I know, because I spent a lot of time out in the municipalities, there were some concerns expressed about the tone of some of our communications in the past, particularly around the closed meeting issues in terms of Twitter in terms of some of the things that came out, some of our systemic reports too that had come out, and we're listening and we're learning. And we recognize that we've got to build relationships in the area so that, because it's to everyone's benefit, we're all here to improve governance. We're all in the same boat. We're doing things in the public interest, and we've got to learn to work cooperatively together. And a lot of the suggestions that we've already heard have been taken into account. And just before we get into the questions, I'm going to go back to the systemic investigations again, because something that I've heard a lot of as well is people say, well, why do you come out with those big glossy reports with pictures and bring so much public attention to those issues? When you say you're about dealing with things informally and using alternate dispute mechanisms. And you know what? In most cases, that's what we're about. We only investigate as a last resort. And we really want to resolve things as cooperatively, as quickly as we can. But sometimes there are those intractable issues of great significance that the only way that we're going to be able to act as a catalyst for change is to bring public attention to the matter. And the case that I always use to demonstrate that is the newborn screening case. We looked at this issue in 2005, and it came to our attention because we were investigating a question of compensation, reimbursement of drug expenses for a young man who had a rare metabolic disorder. And he was denied expenses, it was bankrupting the family, and we looked into the whole metabolic disease program at the Ministry of Health and Long-Term Care. We were able to resolve the issue for that particular individual. However, we discovered that a committee of genetic specialists involved with metabolic disorders that were giving advice to the Ministry of Health and Long-Term Care had basically walked away and stopped working with the government out of concerns for what was happening with the newborn screening program. And at the time, we had about 130,000 newborns born in Ontario every year, and those in hospital have a little small pinprick test on their heel for blood, and it was tested for 2 rare genetic disorders. And the benefit of that is, with these particular disorders, if someone knows they have a child who has that disorder, they can take preventative steps. There may be some medications, there may be some diet and treatment options that they can use to help mitigate the problems associated with those disabilities. And the geneticists had been going to the government and saying, that's lovely, but we are actually now behind the times. The recommended slate of tests for newborns was then 29, not 2. And the technology to be used to do the testing, tandem mass spectrometry, allowed for one single blood test to be scanned simultaneously for all sorts of disorders. But the government was not funding that testing. We were using antiquated testing methods, and in fact the reagent that was used for one of the tests was no longer being manufactured, and the government's stockpile of that drug was disappearing. All this was going on without very much information going out into the public. There were people who were starting to say they were going to bring it out into the light. For instance, the coroner was starting to test children who died under the age of 2 for genetic disorders, and was finding a significant number were dying of undiagnosed metabolic disorders that other provinces, other countries, in some cases third world countries, were testing for. So there was a lot of concern there, but we didn't know about it. When we found this out, we launched a second investigation into the newborn screening program. And what we did is we shone light on the issue as a lessons learned. How could this happen? How could a significant issue, and this is geneticists were telling the government that 25 children were dying each year in Ontario because of the failure of the government to enhance its newborn screening program, and 25 were becoming irretrievably brain damaged. So you've got this very significant issue. Well, how could it have fallen through the cracks? How come there wasn't the momentum in government for change? And what we found is there was really a leadership vacuum. People were working in silos. It was a very unique program that wasn't a good fit with a lot of the branches in the ministry. And without that leadership, without that will, it fell through the cracks. And people suffered significantly as a result. So we brought up a report that really highlighted the systemic flaws in that system as a learning example, and we helped create momentum to improve the newborn screening system. The government knew it had to do something. It couldn't wait forever. As I said, the reagent was disappearing for one of the tests, but it was looking at sort of modest improvements to the screening. As a result, though, of us bringing this to light, of creating that public pressure, because we got out there and the newspapers started telling the story that had been going on in the background, but people weren't aware of. And because of that, we helped spur on significant change that helps save lives. There is now a state-of-the-art testing facility at the Central Eastern Hospital for Sick Children in Ottawa, and we are testing for 29 genetic disorders at birth. So that's the reason sometimes the Ombudsman has to go out in public and has to tell the story and has to get attention for very significant issues in order to inspire systemic change. One of the things I will also mention, we're making this pitch. We are in expansion mode. We are looking for early resolution officers, investigators. Please check our careers section if you have any interest. Refer people who may be interested in this area. And we're also looking for individuals who have expertise, experience in the areas, new areas of jurisdiction that we have. And we give you some information about how to follow us, as Ashley mentioned, our Facebook, on Twitter, our YouTube. Sign up for our Watchdog newsletter. And we're going to take some questions now. I think we've received some from by email. Because of the large number of questions that we received, we may not be able to respond to every single one. Some of them may have been actually answered in the course of our presentation, and Ashley, our communications manager, is going to facilitate our Q&A session today.
All right. Well, thank you very much, Laura and Sue. And also, thank you. I realized I neglected to introduce myself to you all earlier. I am the communications manager for the office. So we've received quite a few questions, and I'm just going to go through them, fairly quickly, although we are doing very well for time. So the first one, how does your office work with MPPs and constituency assistants, and what can municipal staff expect from you when dealing with them?
I can answer that one. In terms of MPP offices, they have a little bit of a different role compared to our office. They're more representative, more advocating for those who contact them. The Ombudsman's office, as we've described today, we're not advocates. We conduct reviews, and we're looking for information and evidence to support our work and the decisions that are made. What I can tell you is this. When we call your office, we really do rely on your cooperation in resolving complaints, and we have a very good track record so far. We've been able to resolve a number of complaints through cooperation with many municipalities by working with them. I also want to let you know as well that we will keep you informed along the way as we conduct any review. And, as mentioned by the Ombudsman, Mr. Dubé, there will be no surprises. We will keep you informed along the way, and we will let you know the outcome of our review as well. Thank you.
Thanks, Sue. Second question. We had a question about services that share funding with the province and the municipality, and where council has made a decision on the level of benefit funding on a discretionary item, for example, such as Ontario Works. Can the Ombudsman look at items like this?
When I talked about administrative conduct at the beginning, I sort of differentiated between legislative decisions and the administration of those decisions. So if we got a complaint about the level of funding, for instance, for a benefit, a discretionary benefit under Ontario Works, we would see what the decision was, what the requirements were, how that decision was implemented in the particular fact situation, and there may be no issue, we may not find no issue, but there may be circumstances possibly where we might find that the decision itself is causing a hardship unnecessarily, it may be unreasonable, where we might make some recommendations for change. Ultimately, it's up to the municipality to decide whether or not to implement that. But there are circumstances, there are limited resources that municipalities have, and there are just some cases where they have to make hard decisions, and we recognize that. The same happens in terms of the provincial sector. We look at what circumstances came to bear, what are the facts, and make an assessment as to whether or not there is anything that we can do to help. In a lot of cases, it will simply be, that they went through the process, they're entitled to go through that process, they're entitled to reach that decision, and as long as they've communicated that to the individual appropriately, that may be the end of it. Again, it really depends, as a lawyer, I get used to saying this, it really depends on the individual facts of the case, and we look at each case on an individual basis.
Thanks, Laura. And you did touch on this quickly, but what can or can't you investigate about the City of Toronto?
Yeah. Anything that is within the jurisdiction of the City of Toronto Ombudsman, we do not look at. That being said, the Act specifically says we still have authority to do systemic investigation. I think it actually says own motion investigations, but in most cases those are systemic. People can complain to us about conduct of council. It's not within the jurisdiction of the City of Toronto Ombudsman. There may be other organizations, municipal organizations reporting through the city or connected to the city that do not fall within the City of Toronto Ombudsman's authority. There may be, for instance, an integrity commissioner or other accountability officer of the municipality. There may be circumstances where we could get a complaint about that office. And again, we would look to see what was done. We are not there to redo the Integrity Commissioner's investigation and come up with our own report. We are there to see what is the context under which the Integrity Commissioner worked, what was the issue they worked with, what did they say, were there reasons. We have jurisdiction over many, many tribunals in the province, and similarly, we would look to see did they comply with their legislative mandate, their policies, their procedures, administrative fairness principles. Did they provide reasons, intelligible and clear reasons to explain their decisions? Those are the kinds of things we look at if we're looking at an accountability officer.
Thanks. Next question. Do you accept complaints from whistleblowers? And if so, how do you protect them?
We regularly are contacted by whistleblowers, and yes, indeed, we do accept complaints from whistleblowers. They are often valuable, a very valuable source of leads for further information. In terms of protections, we explain to them that under the Ombudsman Act, our reviews are conducted in private. We have strict confidentiality provisions, and we do not provide the names of our complainants without consent. We take steps also to educate whistleblowers in terms of how to contact our office so that they can keep their identity private. And we also take internal steps within the office to protect the identity of whistleblowers.
Thanks, Sue. My municipality hasn't appointed a local ombudsman or integrity commissioner. Can the ombudsman force council to put these local accountability officers in place?
The simple answer is no. The longer answer is we really encourage municipalities to have, well, at the very least, a complaint resolution process in place themselves. We also encourage some form of integrity commissioner. It can be contract, it can be shared with other municipalities. A number of municipalities are going out and sharing somebody who can look independently into what's happened in terms of complaints about council conduct. As Sue was mentioning, the one case that we got, if you get complaints about councillors, it's very difficult for the clerk or administrative staff to be investigating those. It's also very difficult for council as a whole to look into those. There's an advantage to retaining somebody to address those particular complaints. And we're really not intended to be the frontline complaint resolution vehicle for complaints about council members. And you may find that if we do get a complaint about a council member and you don't at a municipality have any internal mechanisms, one of the first things we're going to do is recommend that you do adopt some form of resolution process. Now, we understand that not all municipalities are created equal. They come in different sizes, they have different resources, there's different contexts, so that's all taken into consideration. But there are a lot of good precedents out there there now. If you look at AMCTO, for instance, you can see where folks have created codes of conduct and have created integrity commissions. That's another issue as well. It wasn't raised, but at this time, not all municipalities have codes of conduct with respect to council conduct. It's something we recommend. I know that AMCTO recommends it, and that you have a viable enforcement method for those codes of conduct. Now, the Ministry of Municipal Affairs and Housing is also looking at is currently reviewing municipal legislation, and I know that is one of the issues it's considering, and one of the things that has been floated is having mandatory codes of conduct.
Thanks. A question about Local Authority Services, LAS. The municipality I worked for appointed LAS for closed meetings. Can people now complain to you about LAS decisions?
As I mentioned, the Act does not provide that we have authority over agents, closed meeting investigators that have been directly appointed by the municipality. There was, in the one version of the Bill 8, as it was passing through the House, there actually was a provision which sort of looked like we would have ultimate say in terms of closed meeting complaint investigations. That was removed during the Standing Committee review, clause by clause review of the bill. But there may be situations where we might get involved in terms of the municipal side. For instance, if there's a closed meeting investigator out there that issues one-line decisions. I mean, that's an extreme case, but yes, you have violated, or no, you have not violated the rules. We might talk, and if people are raising concerns about it, we might talk to the municipality and suggest that they may want to give some direction to their closed meeting investigator to ensure that there are clear, transparent, intelligible reasons explaining the analysis as to how they got to that particular conclusion.
Thanks. So once you finish investigating a complaint, does the municipality get a copy of the report, and do you publish the name of the complainant?
I guess firstly, we have not launched any formal investigations of any municipalities. In the event that we do launch an investigation, as mentioned earlier, you would be notified. There would be no surprises. On the completion of the investigation, and in the event that the Ombudsman makes recommendations, we are required to provide a municipality with the opportunity to respond and to know the information before the Ombudsman makes a final report, and that final report, of course, would be provided to you. But there would be lots of built-in opportunities for input. We want to receive information in your position, so you would ultimately get the final report, but you would be involved along the way. In terms of publishing the name of the complainant, we're not required to do so, and we would only do so on consent of the complainant.
If I could just add something
Absolutely.
to that, because I think in the municipal sector, you're familiar with closed meeting complaints. In a closed meeting complaint situation, in most cases, we are not disclosing the name of the complainant because it's not really relevant to the issue. Holding an improper closed meeting affects all citizens equally. In terms of individual complaints to come to our office, as Sue said, we get the consent of the individual to contact the organizations, and in some cases, it's necessary. It will be self-evident that that's the individual who is raising a complaint. There may be cases when, and in fact, in a lot of our systemic investigations that are conducted by the Special Ombudsman Response Team, we do identify complainants, and that's because with their consent, we use their stories, and we use their stories to create a human face. When you use individuals rather than hypothetical situations, it creates more momentum for change. People have more difficulty dismissing impacts on individuals who are identified and are made real for them. So we do at times use their names. Sometimes people also ask, is my name going to appear in your report when we're investigating? And for the most part, we do not identify individuals from public sector organizations in our report. We may refer to positions if that's particularly relevant. There may be cases where they're very senior level officials who we're quoting where we may identify them. But we're not investigating individual staff members. That is not our focus. We're looking at the organization as a whole, and we see it as the system. The organization is responsible for the system. It's not about any individual employee. And that's, again, one of the reasons why we're an investigator. We don't have hearings. People don't come with lawyers representing them. That's not what we're about.
Thanks. So this is actually our last question, so we may end a little bit earlier than planned today. So a question about how a municipality can keep track of ombudsman complaints if our staff call the relevant staff person directly instead of going through a appointed contact person.
Okay, it hasn't been our practice to deal with contact persons at different organizations. This is because in our long history of experience, working with a contact person can oftentimes result in delays in terms of reviews, and also sometimes leads to a bit of a broken telephone in terms of the messaging. So it hasn't been seen to be very efficient and effective for the organization or for ourselves. So generally, we don't work with contact persons. What we try to do is speak with the individuals who are directly involved in the complaint. In terms of municipalities keeping track of our calls, we understand that there are many of the organizations do want to keep track of our calls and our contacts, and we tell them that yes, absolutely, that's something that would be the responsibility of the municipality to, for example, keep track of.
You can also contact us. I think it's really important to keep the channels of communication open. If you want to find out how your municipality is doing, if you have, statistically, if there are complaints that you don't know about, we may not be able to disclose the details because of confidentiality, but in circumstances we may be able to provide statistical information about the number of complaints or the general area of complaints. And also, if municipalities have any feedback they want to give us, if they have a concern, maybe they've received a call and they think that we're not following our proper process, or if they have questions, we really want to encourage you to contact us. We're all learning, and we want to make sure we have the best process possible. So please feel free to contact us with any questions or concerns you might have.
Thanks very much, Laura. Thanks, Sue. Well, that brings us to the closure of our session on complaints about municipalities. This will be archived and posted online on our website. We will contact everyone who signed up to register and participate to let you know when, as well as send the information out on Twitter, on Facebook, and through our newsletter. So lots of ways to share it if you'd like to share this with your colleagues or with anyone you think might be interested. So thank you very much for tuning in today. Thank you to our presenters. Thank you to Mr. Dubé. And yes, please check out our website. And if you have any questions, all our contact information is available right there. Thanks very much.